Yes, sir. Nope. Nope. It's not. It's not. Josh. It's not. 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 It is. It is. It is. I was so totally ready. I was definitely prepared. Absolutely. I'm professional. So, we are on video 300. Yes, sir. Yes, sir. I'm so proud of us. You have no idea. All right. Hyena banana. Here we go. Here we go. We're going to OJ.
Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas. People represented, Mr. Kellberg, Mr. Lynch, Mr. Darden, and Ms. Clark. Jury is not present. Counsel, anything we need to discuss before we invite the jurors to join us? Mr. Kellberg.
Yes, Your Honor. To follow up on several matters that we briefly discussed last evening. First of all, and I informed Mr. Shapiro, Dr. Lachman, has had a chance to as well, the document or documents in the category, I should say, because there's not evidence that we are aware of that any specific such document exists, but Mr. Hernandez, who is the director at the medical examiner's office, had no independent recollection of seeing any such document, but he was at home when he was contacted last night. He has checked in this morning, and he will contact us, and if he hasn't by about 9:30 or 10 o'clock, 10:30 break, Dr. Lakshmanan will call him because he was going to check through the records of which he is the custodian, has them, to see whether any such type of document exists.
All right.
Second order of business is we've been talking about other people's mistakes for about 6 or 7 days. It's appropriate, I think, for me to talk about one of my own with respect to Exhibit 363. The court will recall in that short portion of the prime time live broadcast that there was left in the audio portion a statement made by Mr. Donaldson as he's chasing after Dr. Goldman about an alleged gun incident. Undoubtedly, the court recalls that the court was the recipient of much paperwork and heard much argument regarding the admissibility of any such incident. There was a motion in limine filed by Mr. Lynch and myself to exclude such evidence from cross-examination in the event Dr. Goldman testified. The court issued its ruling, I have it here on April 7th of 1995, and if nothing short of an abundance of caution, basically I'm asking the court to reinforce that that is its ruling in spite of my error in not verifying that that portion of the tape had been excluded or excised. I point out, first of all, that the court's ruling indicated that the remark only had relevance with respect to potential bias on the part of Dr. Golden. And I don't know if the court needs a copy of its ruling. I have a copy of the court. But the court did not rule that it was admissible on the issue of Dr. Golden's competency, but only as it may be relevant with respect to the issue of Dr. Golden's potential bias against the defense. And the court went on to find under Section 352 that there were so many uncertainties with respect to the incident itself. Number one being whether it was directed to these defense counsel and how the incident occurred and so forth.
So I recollect the details of the argument.
All right. That there's nothing about the incident which is relevant to Dr. Lakshmanan's testimony, which deals with Dr. Golden's competency, and about which there was a statement made by Dr. Lakshmanan in that interview regarding Dr. Golden's competency. So I would ask the court to reaffirm that its ruling stands, that my mistake has not in some fashion, quote, opened the door, unquote, to make what the court found to be inadmissible suddenly admissible. That's the first aspect of my motion in limine I make this morning.
So what? Let's assume that I agree with you that that should not have come in. What remedy are you direct remedy are you seeking?
My remedy is I don't believe we can excise that statement from the disc and say, gee, it was never played before this jury. What my remedy would be is to provide a second copy of the exhibit which has had excised from it that statement. And in the event the jury wishes to hear that exhibit 363, what they would hear would be the same exhibit but with that one statement excised. I don't think that any reinforcement of that information needs to be paid at this point to the jury. That's obviously why I didn't make any effort to stop the tape and raise any issue as to admonishment regarding it as the tape was being played. So all I recommend as a remedy would be to order our office to make a second copy of the exhibit, but one which has excised that one statement and only that one statement, have it marked as Exhibit 363A, and that will be the one that will be offered in evidence, I assume, by Ms. Clark or Mr. Garden at the conclusion of the people's case when all of the evidence admissibility questions will be litigated. At least I assume that's when that will occur. So that's the remedy I suggest.
Mr. Shapiro.
Thank you very much, Your Honor.
All right. Good morning, sir.
The court will recall that prior to the Sam Donaldson interview being played, the court invited counsel to sidebar. And the court warned Mr. Kellberg that this may not be something that should be shown, and the court indicated that you would sustain our objection to showing it. We indicated that we had no objection to showing it, and Mr. Kelberg indicated that although it was not his preference, he had been told by others in his office to show it. Second, the court rules were violated in that this tape was never previewed before Your Honor and myself before showing it, although I have seen it, and I had no reason not to have it shown because it does exactly what the people have said throughout this trial. It talks about the truth, about really what happened in the coroner's office and what happens when fine reporters investigate problems that, for some reason, the coroner does not want to investigate themselves. And even when pointed out, they don't want to investigate it. So this is no different than anything else that takes place in a trial. We are professionals. We are bound by rules of conduct. And on occasion, there are questions that come out that if you had your chance to edit them, you'd like to have them withdrawn and not have them considered. That's exactly what took place here. Further, I didn't want to press the issue of bringing up the incident with Dr. Golden's gun. And after it was brought up, we didn't have any specific information that it was directed towards any attorney. However, following Your Honor's suggestion in the past, we did a Lexis search last night regarding Dr. Golden, and we found an article August 12th in Newsday, which in summary says, as Dr. Golden left the courthouse after being cross-examined by Robert Shapiro, Golden pounded the walls of the elevator and cursed Shapiro, muttering, "Why did he have to ask me that question? Why did he have to ask me that question?" And then they go on to report the gun incident followed. There was a subsequent report that the comments were actually not only directed towards lawyers for Mr. Simpson, but directly towards me, and I will give the court and counsel.
Irrelevant to everything in the whole entire world, sir. There is no relevance to anything you're saying.
So a copy from Lexis of that.
I say lots of things about you all the time, almost every stream. Not about you, but about you. You, not you.
Story from Newsday. So it is our strong feeling that the people had this piece of tape. They elected to show it. After it was shown, it appeared to me that Ms. Clark directed Mr. Kelberg to the problem that was raised, and that's when it became an issue. And the fact that there is no coordination or lack of coordination should not be held against Mr. Simpson. Here is the story from Newsday. Can I give this to Your Honor? Can we
This is Robertson. Make a copy for both sides. All right, any other comment on that issue, Mr. Shapiro?
No, Your Honor, thank you very much.
Mr.
I would
Kelberg.
like to respond, Your Honor. Your Honor, I never take exception to counsel employing hyperbole, and I certainly understand why the federal courts do not allow cameras in courtrooms to cut down on the hyperbole of counsel. But I take great umbrage when counsel misstates the facts. Let me state the facts as to that sidebar conversation. The facts were that the court wondered whether there was going to be an objection made to it. The court never indicated whether the court would sustain an objection or not because the court was unaware of the contents of that particular episode.
The court's comment was, Mr. Kelberg, where are we going with this?
I believe the court is absolutely correct in that, and I think the court will acknowledge that I told the court the content of what I expected the program section to show. Mr. Shapiro was asked, in essence, by the court, as I recall, if he had any objection. Mr. Shapiro indicated he had no objection. The court basically said fine, and then we were going to proceed. Now, with respect to some representation that I was given instructions on playing this, let me set the record very clear, Your Honor, if it hasn't been made clear already. When I am in court representing the prosecution with witnesses, nobody tells me what to do from my office. I am our lawyer in court. It is my judgment. It is my theoretical considerations that go into the tactics that I entertain in presenting testimony. And I can guarantee Mr. Shapiro and I can guarantee this court that Ms. Clark had absolutely no input into any decision as to whether this would or would not be played. The decision was mine alone, and I have no regrets whatsoever about doing it, and I have no doubt that the evidence would have been admissible had Mr. Shapiro, as his first area of cross-examination, gone into Dr. Lakshmanan's assessment of Dr. Golden's competency in performing these audits. autopsies. This jury has a right to know that Dr. Lakshmanan made a comment that I believe he rused having made to Sam Donaldson. And I must say, I believe this jury will see the kind of ambush tactics employed by Mr. Donaldson and find that if that represents sound journalistic practices, then there is a definite problem with the way the Fourth Estate practices its profession. Now, with respect to a conversation with Ms. Clark, let me point out my conversation with Ms. Clark was with respect to the limited amount of time we had left yesterday afternoon. And I indicated to Ms. Clark I had various alternative pieces of evidence which I could play. And because I don't know what her schedule is and whether she can stay till 5:45 or not, I wanted her to know what was available. And she indicated that she would prefer that we play this incident. I said fine, because quite frankly, Your Honor, it's either yesterday afternoon or it's this morning, and to my way of thinking, it makes no difference whatsoever. I have a plan in my mind as to how the evidence will be presented, and as long as I present that evidence, to me, it makes no difference at all. So to accommodate Ms. Clark's request, and in full agreement with her request, I played the tape at the time I did. I find it most interesting that in Mr. Shapiro, instead of posturing for the camera, would have focused on the argument I made to this court a moment ago, that he might have tried to respond to the issue, is this relevant to any issue regarding Dr. Lakshmanan? And the answer, I believe, has to be taken as a tacit acknowledgement by him that it's not, because the court found it was relevant, if at all, to bias. Now, Mr. Shapiro is relying upon a newspaper article, which of course is hearsay, reporting an alleged incident with Dr. Golden in the elevator.
I'm not relitigating that aspect.
All right. As
The
far
only
as
issue is, what do we do with 363? So why don't you confine your comment to that, Counsel?
with 363, my suggestion is, as I indicated, Mr. Shapiro has offered no alternative suggestion. I merely indicated a belief that the portion should be excised to conform with the court's ruling, marked as 363A, and that would be admitted. But on the other hand, I'll tell you right now, Judge, the alternative remedy, keep it as is. They want to hear it, let them hear it. They send a question out, hey, do we have any evidence about some gun incident? The answer is going to be a big N-O. And you are not to infer or speculate about any such evidence. Either way, it's fine with me. I don't care. But I came down here because I made a mistake. I wanted it brought to the attention of the court. I wanted the court to handle it in an appropriate manner, and that is the purpose behind that. So either alternative is fine with me, Judge.
All right. Thank you, Counsel.
There is a second aspect to the motion, not as to the tape itself, but as to the two incidents, the Gay Phillips incident. Mr. Shapiro has indicated at the sidebar also last night that he believes evidence of the legal significance of Dr. Golden's mistakes are fuel for fodder or fodder for the cross-examination of Dr. Lakshmanan. As the court will recall, I asked Dr. Lakshmanan whether or not there was any medical significance to Dr. Golden's mistakes dealing with entrance exit wounds and dealing with the range of fire in the two cases. Dr. Lakshmanan indicated that they were significant mistakes, and he testified in his opinion why they were. The question is, what is the legal ramification that flows from each of those? The legal ramification is irrelevant to the issue of the medical significance, because the whole thrust of this evidence goes to the significance or lack of significance of any mistakes Dr. Golden has made in the course of the autopsies he's performed.
Let's assume that to be true, though. Isn't it fair game for the defense to then argue that point during closing argument?
Well,
That given these medical mistakes, obviously they're going to have a legal consequence if they're believed by the trier of fact, and if they in fact false or not true.
It may well be a legitimate argument to suggest that many things can flow from medical mistakes of significance. And I would not find it inappropriate to argue in the abstract, keeping in mind there would be no evidence, because I'm indicating to the court my belief that such evidence is inadmissible as irrelevant, 352, calling for speculation outside the expertise of this witness, and a number of
Well,
other grounds.
Mr. Kalberg, I'm not inclined to entertain much more of this argument at this point. It's premature. You haven't finished your presentation. I don't have an indication that the defense is going to offer that.
All right, I just want to alert the court then, because I would ask for a ruling in the event Mr. Shapiro intends to go into that area on cross-examination of Dr. Lakshmanan.
All right.
And I have nothing further than Your Honor.
All right, thank you. All right, the prosecution is ordered to prepare an alternative Exhibit 363. It will be designated 363A. It is to include the entirety of what was played yesterday with the exception of the comment regarding the gun incident. Court still finds that subject to 352. All right, let's have the jurors.
Well, if you weren't awake, you are now. I don't know what just happened, but they're mad. There was a sentence that was played yesterday in that video that we watched that I guess everybody hates. And I don't even know what's going on with the gun. The only gun that we're not even allowed to know about that gun. There was a gun in the OJ trial. or in the OJ case. That was when OJ had
Video
the gun
VHS of 363 and 363A.
while he was fleeing very slowly in the Bronco. But that's not in the trial. So they did this to themselves. They played like Dateline footage in the trial. That's just stupid. It's stupid to do. They did it to themselves. You know, whatever happens, happens.
Since we won't be able to provide the jury with a Laserdisc player.
So you want just the VHS?
Just VHS.
And you want to make the 363 VHS as A and the 363 modified?
Better make sure it's the
No,
right
363
VHS tape.
will substitute a video
Trust me.
tape for the Laserdisc as 363. Unless you want to donate to the court a Laserdisc.
All right.
Gentlemen, please be seated. Doctor? All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. Dr. Lachmanan is on the witness stand again. And Mr. Kelberg, is that some of your material there? All right, good morning again, Doctor. Sir, you were reminded you are still under oath. And Mr. Kelberg, you may conclude your direct examination.
I have every expectation of doing so, Your Honor.
Thank you.
Your Honor, I have a series of documents. I marked them by pen, but for the record, may I mark them?
Yes.
These deal with chain of custody documents. As 364A, an autopsy evidence collection log dated June 14, 1994. As 364B, an evidence log for the Goldman Ron autopsy. As 364C, an evidence log for the Simpson Nicole autopsy. As 364D, a document entitled Drop Box Log. As 364E, a document which talks about cassettes prepared in the laboratory by DME and contains many other entries. As 364F, a one-page document with the handwritten entry at the top, toxicology log. As 364G, a similar appearing document, but this time with more writing in the middle and with the date of May 10th that appeared in the upper left-hand corner of the page excluded. As 364H, a seal concerning blood obtained before embalming in the Goldman autopsy. And as 364I, a similar document for the Nicole Brown Simpson autopsy.
All right, they'll be so marked.
And, Your Honor, I have blow-ups, which counsel, I believe, will stipulate are accurate blow-ups. Mr. Shapiro? I'm sorry,
Certainly.
Okay, guys, we are on June 14th
Mr. Shapiro?
of this riveting trial.
Certainly.
I don't know when in July this guy takes over, but it's coming soon. We're going to get the defense part soon. And then the fireworks begin. The riveting testimony that we're hearing now, though, is what we're getting through.
And Mr. Fairlow is going to be helping me out with the Elmo. But first, Doctor, let me show you these documents that I've just marked as exhibits 364A through I.
The Sixth Sense movie. Did that come out before 95 or after? Does he walk?
Yes.
Does he
Doctor, in
drive
general
around
terms, are you familiar with each of those documents?
with a bumper sticker in his car in 1995 that says, "I see dead people"? Would anybody understand that back then? I'm going to Google it.
Yes, I am.
In general terms, please describe what each of those documents is.
364A is the autopsy evidence collection log. This is a log to reflect the which specimens were collected during autopsy, and that is reflected on the current cases being discussed. And then this log is, when the specimens are received in
It
the
was-
toxicology lab, it is,
It was 1999, so if he drove around with a bumper sticker in 1995 that says "I see dead people," nobody would understand, except for like Doctor Who.
marked off by the person receiving the specimens in the lab, saying they received the specimen, they put their initials, and then they keep a copy, and a copy is sent back to the autopsy area.
Doctor, is that document a true and correct copy of the particular autopsy evidence log from the two cases of Ronald Goldman and Nicole Brown Simpson?
Yes.
Are the entries which are made on that document entries made by employees of the coroner's office acting in their official duties as such employees?
Yes.
Are the entries which they make entries which are made at or near the time of the events which are recorded in that document?
Yes.
Perhaps instead of going forward to the next one, could Mr. Fairtlow put that document up on the Elmo and let me show you the blow-up? And I'm not sure we got a stipulation yet on the record. Mr. Shapiro, will you stipulate that we have blow-ups that correspond identically except for size to the documents which have been marked as 364 A through I?
Thank you, Counsel.
Doctor, again, with the court's permission, if you could step to the board with the pointer and tell us what is the information that's contained in this document pertaining specifically to the Goldman and Nicole Brown Simpson autopsies.
Yes. This is the autopsy evidence collection log. The date of this log was June 14th, 1994. You have 5135 is the coroner's case number, belonged to the number given to Mr. Ron Goldman. Golden is a medical examiner. This is the verifying forensic technician. Verifying forensic technician was George McDowell.
George who, Doctor?
McDowell.
Can you spell his name? for the record?
McDowell.
And what is he supposed to do by initialing that document?
That is, he checked that these specimens were collected during the autopsy. The specimens collected on Mr. Goldman were blood, stomach contents, bile, a histo jar, that is the storage jar with the tissues and formalin, and piping blood. And these initials are JM, which is the Mr. Murillo, who's the technician in the toxicology lab. When this log comes up, he initials saying that he received it and checks off that.
Can you spell Mr. Murillo's last name?
Murillo. So that belongs to Mr. Goldman's autopsy. Unfortunately, due to the copying, this is a little bit dark here. This is 5136 here, Dr. Golden, and this belongs to Ms. Nicole Brown Simpson's specimen collection. They collected blood, urine, the storage jar, which contains the tissues, and the typing blood. And again, the same initials, indicating Mr. Murillo received it in the toxicology lab.
Doctor, is a document of this nature prepared for each day of the year concerning all autopsies performed at your offices?
Yes, this is the initial chain of custody of specimen collection at the autopsy room, and then I gave you the next stage, which is the toxicology lab, wherein a person receives it and signs off on it. So you've got a chain of custody from the autopsy room to the toxicology lab, and already discussed the Form 15, which is the initial log saying the doctor did collect it. He initials the 15. So so far we have got the chain of custody for these specimens.
All right, Doctor, why don't you, if you wouldn't mind, please just stay where you are. And by the way, Your Honor, I've marked these big boards correspondingly to the small paper exhibits, but adding an extra letter. So this one is 364 double A to correspond to the blow-up of 364A.
Thank you.
Doctor, let me put up now the blow-up that has been marked as 364 double B. In general terms, what kind of document is this one?
This is the master evidence log for the which records the collection of any physical evidence, hair samples, typing blood, etc. for the department. Usually the investigator initiates this when the evidence collection starts. This particular exhibit refers to Mr. Ron Goldman's evidence log maintained by the Department of Coroner. As you can see, the coroner's number is here, 5135.
Is there an individualized evidence log kept for each case handled by the coroner's office?
Yes, it is. And what this card will reflect is when a particular piece of evidence was obtained, the date, the person obtaining it, how long it was in our custody, and also if it was released, the date of release, and the person who obtained that specimen from us will be recorded also.
Are the entries which are made on this document made by employees of the coroner's office
Yes.
in the course of their official responsibilities with the office?
Yes.
Do the entries reflect events that occurred at or near the time of the entries?
Yes.
Now, doctor, can you take us through the specifics of what this document shows?
Yes, I already mentioned that this particular exhibit belongs to the evidence log of Mr. Ron Goldman. We'll start with the typing blood swatch.
Keep your voice up.
Typing blood swatch. This refers to a swatch which is made on every case where typing blood is obtained. It was done by Mr. Adrian Dersidan, D-E-R-S-I-D-A-N, and it was made on June 15th at 8 o'clock.
Mr. Dersidan is an employee of the coroner's office?
Yes, and it was received in the evidence room by Mr. Sigler. Mr. Sigler, who's our senior criminalist, who's also in charge of the evidence area of our office. And it was released to Mr. Phil Van Natter of LAPD, robbery homicide, by Mr. Sigler on June 15th at 8:45.
The next entry, doctor?
The next entry, this is for the typing blood, which I discussed so far. This just indicates that the swatch was made.
I'm sorry, the released material is what?
The typing blood.
Is that in some kind of container, or?
It's in a test tube, the tube.
So that tube with whatever blood was in it was released to Mr. Van Adder?
Yes.
All right, the next entry then.
Then we have the hair kit. I discussed this, I think, on Tuesday last week. Ms. Claudine Ratcliffe obtained the hair samples from Mr. Ron Goldman, put it in the drop-off box, which I mentioned, and on June 13th in the afternoon at 14:40.
Doctor, is that mailbox-like device?
Yes.
All right.
Then Mr. Patino retrieved it from our drop-off box in the evidence and took it to the evidence room on June 15th, 94 at 7 o'clock. And as we discussed earlier, Mr. Grandis of LAPD SID retrieved it from our department from Mr. Patino on June 24th at 9:30.
The next entry, doctor.
Next entry is the clothing. The clothing, as you recall, Mr. Goldman had shirt, pants, shoes, and socks. As I discussed earlier, on June 14th, the photographs were taken. During that time, the clothing was removed. And if you recall, it was Mr. John Marsden, who was our autopsy technician, forensic photographic technician, who took the clothing off. It was done on June 14th at 8:40. As I mentioned earlier, this clothing is dried. And when it was completely dry, Mr. Patino retrieved it, kept it in the evidence room on June 20th, 94. And Mr. Grandis took custody of the clothing from our office from Mr. Patino. And Mr. Grandis works for LAPD SID. And that was done on June 24th at 9:20 in the morning. And of course, this just refers to this asterisk here, that only the whole blood was, the blood was released to Mr. Van Natter.
For the record, you're referring to that initial entry under typing blood?
Yes.
Referring to the whole blood in the tube that you
Yes.
already described?
Yes. Then the typing blood swatch, as I mentioned earlier, was made by Mr. Desiderian on June 15th. Mr. Ziegler got custody of it, of the swatch, at 3 o'clock in the afternoon because it has to dry. And then that was released to Mr. Grandis of LAPD SID on June 24th at 9:20. The fingerprint card, palm print cards, as you recall, the fingerprints and palm prints were obtained by Mr. Jacobo of our office. It was obtained on June 13th, the day the remains were brought to our office. Mr. Patino received those cards on June 15th in the evidence area, and it was released to one Mr. Dubé of LAPD by Mr. Patino on June 16th, 1994 at 8:45. The liver temperature thermometer, which was used to obtain the liver temperature on both the dissidents, was kept in our custody on June 22nd by Mr. Mahaney. He calibrated the instrument that day, and Mr. Ziegler has it in custody since February. It has not been released. It's still in our custody. That's the thermometer which was used to obtain the temperature.
Anything further about this document, Doctor?
No.
All right, let me put up what I'll ask to be marked as our 364 double C, a blow-up of the small document. And it appears to be a similar one to 364 double D, except it appears to refer to Nicole Brown Simpson instead of Mr. Gold. Would you take us, first of all, let me ask you, in general terms, is this the same kind of document as the previous exhibit 364 double B?
Yes.
And would your answers be the same with respect to the manner in which this document is created and retained by the coroner's office?
Yes. The investigator starts the document, and then it's kept in the evidence room of the coroner's office.
And the entries, again, are all made by employees of the coroner's office in their duties as employees
Yes.
at or near the time of the events recorded?
Yes.
Take us through what this document shows, please.
Again, we'll start. Again, this belongs to Ms. Nicole Brown Simpson. Typing blood was received in the lab in the evidence room on 15th. Actually, it was collected. Both the typing bloods were collected by Dr. Golden at autopsy. And in the evidence room, Mr. Ziegler signs off on it, released to Mr. Van Natter the same day of LAPD at 8:45 in the morning. The fingernail kit was processed by Mr. Ratcliffe on June 13th at 13:40 hours, received in the evidence room by Mr. Patino from the Dropbox on June 15th, released to Mr. Grandis June 24th at 9:30. Mr. Grandis of LAPD. Hair kit, Claudine Ratcliffe obtained it on June 13th, 13:40. Patino receives it in the evidence room from the drop-off box on June 15th, and this specimen was also released to LAPD on June 24th. As you recall, the clothing worn by Ms. Simpson was a dress and a panty recovered by our photographer John Marsden at 7 o'clock on June 14th during the autopsy photographic process. The dry clothing was recovered by Mr. Patino on June 16th, released to the same Mr. Grandis of LAPD on June 24th. The liver thermometer already addressed this. One thermometer was used, and it's in our custody. The blood scrapings, as you recall, was obtained by our criminalist from the right thigh and right calf of Ms. Nicole Brown Simpson. This took place on June 13th, and they were placed in evidence and retrieved from the box by Mr. Patino on the 15th and released again to the same LAPD person, Mr. Grandis, on June 24th. The finger and palm prints obtained by Jacobo on June 13th when the bodies came in.
Do I remember that right?
Patino retrieved it in the evidence room on June 15th, released to Mr. Dubé on June 16th at 8:45.
It's been a
Typing
while.
blood swatch made by Mr. Adrian, Desiderian, on June 15th, received by Mr. Sigla at the same time, released to Mr. Grandis on June 24th of 1994 by Mr. Patino.
Just to clarify, I think you said that received by Mr. Sigler at the same time regarding the typing blood swatch.
I mean, in the afternoon.
The same date.
No, Nan,
Yes.
you don't need your brain
Anything
for
further
this,
about this document?
for this
No.
one.
All right, let me show you then.
Actually, the less you use of your brain with this clip, the better. You just let it happen.
Let me take this one down, give it to Mr. Lynch, and put up what I'd ask to be marked as 364,
Okay,
double the...
okay. Real quick.
Mr. Fairlow, is that going to affect the...
Often during this trial, while they're doing stuff, while they're questioning the witnesses, the prosecutors will talk to each other. Like, what is his name? Kyle? That's not right. We're just going to call him Kyle because I can't remember his name. Just said something to him while they were putting the thing up. And it was muted. So oftentimes when they're talking to each other, it gets muted. I assumed the judge did that. He doesn't do that. I wonder how those side conversations, because sometimes they're not muted, sometimes they are. Sometimes they go into it a little bit and then they get muted. I wonder if it's the cameraman, which is the only thing that makes sense to me. So I'm going with that.
Is that too high? I'm sorry, move it forward.
Remember, this was basically like the first trial that was televised, like we see them now. So they were learning everything new.
Doctor, in general terms, are you familiar with this document?
Yes, this is the drop-off log sheet which is kept next to the mailbox which we discussed last Tuesday.
The purpose of this document in general terms?
Is to record who dropped off what evidence in the drop-off log, the drop-off box, and to record it.
Are the entries that are made on this document entries made by employees
That's
of the
very
coroner's
smart.
office?
Yes,
Very
Is the
smart.
document kept in the course of the official duties of the coroner's office?
yes,
Are the events recorded on this document by the coroner employees ones which reflect acts occurring at or about the time of the events recorded?
yes,
Take us through this document as it pertains to these two autopsies.
yes. We'll start. 5135 belongs to Mr. Ron Goldman, and this refers to Mr. Ratcliffe dropping off the hair kit, which was collected on Mr. Ron Goldman, and you can see her initials here. On 5136, which is a case number for Ms. Brown Simpson, a fingernail kit was processed, a hair kit was processed, but we also collected some physical evidence of the blood stains, scrapings taken by Mr. Mahaney, and all these samples were dropped off by Ms. Ratcliffe. She also indicated that she had placed the evidence log card because they they start the evidence log sheet. So that was also made available.
Doctor, before you go
Yes,
to
Court
this,
TV.
sure. Is that a reference to, for example, I don't know if I've got the one for Goldman or the one for Brown Simpson, but is that the document you're referring to?
Yes, see, Ms. Ratcliffe starts off the document, and that's what is recorded there.
All right, that was the log as to Mr. Goldman.
364 double D. Thank you, Your Honor. Let me just outline this area that you've just been discussing, Doctor. I gather this document is used for a number of different cases.
Yes, it's just a drop-off box and a log to show what specimens or evidence was dropped off. And then if you go lower down in the same sheet, 5136 and 5135, 5136 belongs to Ms. Simpson and 5135 to Mr. Ron Goldman.
Keep your voice up, please, Doctor.
This reflects the drop-off of the fingerprint and palm print cards. The prints were taken by Mr. Jacobo, but the drop-off log indicates that it was dropped off by one Mr. Mitten, M-E-T-T-I-N.
Was Mr. Minton an employee of your office at the time?
Yes, he was a volunteer.
A volunteer meaning what, Doctor?
People who volunteer to work for our office.
And when they volunteer to work for your office, are they considered employees in the sense that they have responsibilities as if they were being paid employees to do certain things that are the
Same.
responsibilities of the coroner's office?
Yes, and they work under the
Yo,
supervision
whoa,
of the
whoa.
staff supervising them.
Hold on a
Let me
second.
outline this area. That
What? What did he just say? There are volunteers that work for the medical examiner's office? People volunteer to go work at the medical examiner's office? Come on. Come on. That can't be true, is it?
that you've now been describing. I'll do that in red also.
Thank you, Bobby.
Is there anything else about this particular document that pertains to these two cases?
No.
I don't know.
I'd ask
That's a
for the
good
record to be marked
question.
364 double E. A blow up of the smaller document. Doctor, what kind of document is this?
This reflects the histopathology evidence log, wherein the tissue jar, which is generated at the autopsy, containing the specimens from the autopsies, they are received in the histopathology area, which is a separate section of the laboratory division, and a chain of custody is maintained for the histopathology specimens, and basically you have a reflection of how many jars there were, whether any microscopic sections were submitted, the date they were submitted, any duplicates were made, etc.
Could you keep your voice up, please, Doctor?
Shut up, sir.
The jar.
Son of a gun, guys. I just Googled if the medical examiner's office uses volunteers, and now now Google thinks I want to volunteer for the medical examiner's office. That was a mistake on my part. I did it so you didn't have to. No, the medical examiner's office does not usually use volunteers around the dead bodies, they say.
The whole jar was received on Mr. Goldman, the number is here, the coroner's case number, on June 14th. The name of the DME is here. One jar was received on Goldman and Ms. Simpson each. And on Ms. Simpson, a microscopic section was cut.
Doctor, what is that category that's described at the top? Cassettes prepared in the laboratory by DME. What does that category refer to?
That refers to when you take a microscopic section, you take a piece of tissue and put it in what's called a cassette, which is then submitted, and that is taken to a processing laboratory where it goes through a process wherein the tissue is made into what's called a paraffin block, wherein a histopathology technician can take sections of that tissue, thin sections, so that tissue can be studied under the microscope. And this process is what is done in the histopathology laboratory, and a cassette is, this particular column refers to if microscopic sections were done, and on Ms. Brown Simpson, but not on Mr. Goldman at that time. One section of the brain was submitted on July 1st. I discussed it briefly during my testimony. And then the slides were available on July 12th and returned August 2nd back to the lab. And this refers to the same slide which came to me.
Doctor, please keep your voice up.
Wondering what this date. This says 2194 should be 95 in February this year. I think when we wanted to make duplicates for the defense to send it to the in February this year to Albany, we made some duplicate slides of the brain slide, and that's reflected on the 28th here. 2 slides were made. And originally, I sent the original slide to Albany, and it came back. And when I got the duplicates, I mailed it to Dr. Barton. So that's what is reflected here. And this log is not, this is a copy of a log which is not really up to date, because in May of this year, we cut additional sections at the request of the defense on both the cases. A total of 16 cassettes were cut, 9 on Ms. Brown Simpson, if I recall, and 7 on Mr. Goldman. And the current log in our office should reflect that having taken place. So what I'm saying is this log is a permanent log in the coroner's office. Any additions or entries which are made at a later date, few years later, will be maintained in the same log sheet, so that there's a chain of custody of what sections were taken at what time, as long as we have custody of the specimens.
Doctor, have you examined all of the slides that have been prepared in this case, including the most recent series of slides?
Yes, I have.
And that was part of your preparation before testifying?
Yes.
Anything else about this document, Doctor?
No.
Let me just outline, again in red, the areas that refer to the 2 cases before the court and jury. Anything else, Doctor? You want to add something?
Yes. In Ms. Nicole Brown Simpson.
Sustained. Phrase the question.
Doctor, have we not covered some aspect of the chart to this point?
Yes.
What aspect have we not covered?
Well, an entry which has not yet been made in this particular copy of the log. When Ms. Nicole Brown Simpson's jar was originally examined by the defense pathologist and myself on June 22nd, the spine specimen and the laryngeal specimen were the same jar.
Keep your voice up.
We're in the same jar, but now we have made an additional jar to keep the specimen because we did some additional examinations. As you recall, during my testimony on Ms. Simpson, we had evaluation by our criminalist on the laryngeal specimen and spine specimen. And as you recall, we also did x-rays on the spine specimen. So when we retrieved it, we put it in a separate jar. So we have 2 jars on Ms. Simpson and 1 on Mr. Goldman. I just wanted to reflect that also. And that will complete this chart.
Doctor, for the record, I'd ask that this first page of this blow-up series with the toxicology log handwritten entry be marked as 364 double F to correspond with the paper document. Mr. Fairlow, is that going to interfere? Doctor, in general terms, can you tell us what this document is?
This is the internal toxicology specimen log. As you recall, you saw the autopsy specimen log sheet wherein the log comes up, the toxicology technician signs off that he received the specimen, but that log sheet goes back to the autopsy area. He just keeps a copy. So a new log is maintained in the toxicology lab, and this is the internal toxicology log with reference to the specimens on each coroner's case, and this particular document refers to the, both our cases. 5135 is Ron Goldman. We received a blood sample. They also received stomach and bile.
You've got some letters that you've just been pointing to. Can you tell us what those letters refer to?
June 15th, ST means stomach and B means bile.
Is that a common designation used by personnel in your office to refer to such things?
Yes, and it is the same Mr. Joe Murillo, M-U-R-I-L-L-O, who received it in the lab. And 5136 is the blood specimen on Ms. Nicole Brown Simpson, plus we got urine sample, received U stands for urine. And of course, don't worry about the date here. We use old books so that we don't, we use the same books, but the dates are different.
I was going to ask you, this document has up in the left-hand corner the date May 10th. Is that the date that refers to the entries that appear on this document?
No. The date is the correct date here. I just said that we use an older book because we have some books available, so we just use it. But the key thing is the date of entry for each specimen.
And these numbers that appear to be stamped in vertically, starting with 005127, I believe, in the upper left-hand corner, what do they refer to, Doctor?
They are the different cases which have specimens for that day because, in the coroner's office, our case assignments go from the number 1 for each year till the end of the year. So this particular day on June 14th and 15th, all those case numbers are the ones which were processed in our office.
Is this document prepared in advance with respect to those pre-stamped numbers?
Yes, to a certain extent it is, but the entries are all made as the specimens are received.
And are the entries then made by employees of the coroner's office in the course of their official responsibility?
Yes.
And are the entries to reflect acts or events which occurred at or about the time of the entries which are made?
Yes.
Anything else regarding this document, Doctor?
No.
Let me outline, if I could please, in red, the areas that you were just identifying.
I really hope after he leaves the courtroom tonight, someone does not come in and break all of his markers. That would just be a tragedy, wouldn't it?
Accurate circling of the area you've just been describing, Doctor.
Yes.
Let me flip on this chart. And, Your Honor, I ask if this blow-up be marked 364 double G to correspond with the paper document.
Yes.
Doctor, what is this document we're looking at?
It is the same document, only thing is there are more entries made here with reference to the what happened to these samples. As you recall, this February of this year, I think February 17th or 18th of this year, the defense wanted specimens sent to Albany, and I was in Seattle, and we coordinated the release of those specimens. Basically, I think a blood sample from each blood bottle was sent to Albany, and also I sent stomach contents on Mr. Goldman, which was available for the defense pathologist to examine. So in that particular day, I communicated with the DA's office, who in turn communicated with the defense attorneys. I communicated directly with Dr. Barden, and we arrived at what specimens they needed. And all these entries reflect the removal of the specimens from the lab, transmission to Albany, and then back, and when they were received. So a chain of custody is maintained at all times of any specimen in the coroner's office, and it shows that we have a very good chain of custody in our office.
Please take us through that chain of custody as reflected by the entries here, Doctor.
As you can recall, this part I've already discussed, and this 5 ml of blood and stomach contents on Mr. Goldman, 5 ml of blood on Ms. Simpson.
Doctor, what does the word aliquot mean?
Aliquot means a small amount of blood in a container.
Just a sample?
Yes, we didn't give the whole sample because that was agreed on by Dr. Barden and myself, what they needed. And then it was released by Mr. Gary Siegler to Brian Hale of LA County District Attorney's Office on February 17th at 4:45, and it was returned to the Tox Lab login room by our Chief of Laboratories, Joe Muto, on February 21st, 1995 at 1500. That is, the stomach contents was returned. The blood sample we sent, they retained. And then we also put an indefinite hold on all the specimens we have on this particular 2 cases.
Is that indicated in this document?
Yes, it says hold. And this hold has been there since July of last year.
Does that terminology have a special meaning in the coroner's office?
Yes, it does, because, we do 6,000 autopsies and 3,000 examinations a year, so we have retention times for every specimen collected. We can't retain them indefinitely. But if in a particular case a request is made for a hold, then we retain it, and that's what it reflects. So otherwise, these specimens get discarded on the retention time schedule maintained by the coroner's office.
And does that complete a discussion of the entries that have been added on this document 364 double G to refer to the chain of events for the release and subsequent return of some, but not all, of the material sent to Dr. Baden in Albany?
Yes.
Anything further about this document?
No.
Again, Doctor, any of the additional entries, would these be entries made by employees of the coroner's office in the course of their official duties?
Yes.
And made at or about the time of the events which are recorded in the document?
Yes.
Let me flip the page. Try to flip the page. Doctor, and I'd ask Your Honor the record reflect a designation of 364 double H for a blow-up of the single-page document.
Yes.
Doctor, in general terms, are you familiar with this document?
Yes, I am.
What is this one?
This is a label which is on every blood bottle where blood sample is obtained from a particular dissident. It's got 2 layers. One layer is left on the bottle. The outer layer is taken off in the toxicology lab. And this is the copy of the label of the blood bottle, which was on Mr. Ron Goldman, 5135, coroner's case number. Yes, there's a stamp here, the pre-address stamp.
Thank you, Doctor.
And the numbers, again, handwritten here. And it also says here, I mean, first let's start here. The autopsy was done on June 14th. The sample was obtained at 11:30 by Dr. Golden. He initials off the bottle here that he took the blood sample. And that's the way we know that he has seen that the sample belongs to that particular person. And as you recall, this blood sample was, the label was removed by Mr. Joe Murillo of our toxicology lab as part of maintaining the evidence on this particular case.
Anything further about this document, Doctor?
No.
All entries made by coroner employees
Yes.
at or about the time of the events recorded
Yes.
in the course of their responsibilities
Nothing further,
as
he said.
employees of the coroner's
Move on.
office.
Yes.
Let me flip or try to flip.
Don't flip. Just throw that whole thing in the trash, please. He flipped.
To a document, Your Honor, it has to
Flip
bear the
you.
designation 364 II.
Yes.
And again, just a blow-up of the smaller single-page document. Doctor, this appears to be a similar kind of form to the one you were just talking about. Is that an accurate assessment?
Yes.
What is the difference, if any, between this form and the one we were just looking at, double H?
This belongs to Ms. Nicole Brown Simpson, 5136. This is a pre-stamped imprint card information. Handwritten case number again here. Blood sample was obtained by Dr. Golden, June 14th,
Okay.
9:30 in the morning.
You answered a
Mr. Murillo
question
received the blood sample on June
that I
15th.
asked you a little
and
bit
Dr.
ago when you stepped away, Siobhan. That answers the question because first it answered the question when you said sunset, and then it answered the question again differently. I said, are you in Ireland? I'm trying to remember. I said, are you in Ireland? And then I said, no, wait. I think you're in the Midwest, but I could not remember where you are. So you said, sunset looks really cool, the way the clouds are. And I thought, okay, Ireland. Ireland, I nailed it. And then you changed it, sunrise, which might still be the Midwest. So I nailed it again. It's either one or the other.
Golden has initially it's upside down, but IG here, June 14th. So that authenticates that he took the blood sample of this particular person on that particular day.
Doctor, again, all entries made by employees of the coroner's office in the course of their official responsibilities
Yes.
and to reflect acts or events that occurred at or about the time of the entries.
Yes.
Anything further about this document?
No.
That does it for this argument. May you take the stand, Doctor?
All right, noted, overruled. Under, yep, under 1280 of the evidence code. Thank you, counsel.
Just going to scroll down for a second to see how much longer Dr. L's on the stand.
Following the meeting on June 22nd, 1994 with Drs. Bodden and Wolf, was a document prepared by Mr. Sigler in your office?
Yes.
What was the purpose of that particular document?
I don't know which particular document you're referring to because we made some minutes during the meeting. I had some handwritten notes and Sigler had some handwritten notes, and it was later transcribed. I had kept a copy of the transcript copy for both prosecution and defense.
Let me find the document again, Your Honor, with the court's permission.
3 days, I think, at most. We have 3 more days of him at most. Oh gosh, we're getting closer, guys. Jeez.
Your Honor, I have what appears to be a 3-page document along with a 1-page handwritten Form 42. The document is dated July 28, 1994. It appears to be a letter from Mr. Sigler to Mr. Hodgman of our office. May it be marked collectively as Exhibit 365.
365.
Doctor, let me show you this series of documents. I'll take the other exhibits away. Are you familiar with this letter and the 1-page Form 42 notes?
Yes.
In general, Doctor, what is this letter, this July 28th letter from Mr. Sigler to Mr. Hodgman?
This is
If I
a letter
wouldn't
sent by
have
Mr.
got
Sigler
sick
to Mr. Hodgman
this week,
based
would
on
be
his
on the end of
request
his testimony.
regarding our weekly meeting of the DMEs on June
Damn.
23rd. This letter was sent out when I was not in. I had not seen the letter before it was sent out, but I have a copy of it because I was on vacation at that time. It reflects to information which was discussed in a DME meeting which we had in our office on June 23rd of '94. And do you want me to go into the contents of the letter, or?
Yes, in general first, and then we'll put it up on the Elmo so the ladies and gentlemen of the jury will have an opportunity to read it.
They discuss the different issues pertaining to the two cases which are being discussed in trial, and we're going to put it up in the Elmo so we can discuss each item as we go through, as you put it up on the Elmo. But what happened was, after the DME meeting on June 26th, they also discussed it in a meeting of the forensic technicians, and these are internal department meetings, but I think somehow the information went to the press, and then we were asked about this information, and that's how the district attorney's office wanted to have input on this information, and that's how this letter came about.
Doctor, would it be accurate as a summary that the information pertains to possible mistakes or errors in the coroner's office that relate to these two cases?
Yes.
And that the,
Sustained. Rephrase the question.
why don't I just put it up on the Elmo?
All right. This will be People's 365.
It is, Your Honor. And let me start with page 1. Oh, why don't we just start at the top, Mr. Fairtlow, and focus it in so the ladies and gentlemen of the jury will have an opportunity to read it. And, Your Honor, I'd ask that the jurors have an opportunity to read the letter, and Mr. Fairtlow can move it at any time appropriate from the court's perspective down so all paragraphs of each page can be read.
All right, 984, can you read that? Thank you.
Bye, Siobhan. It was great seeing you again, love.
All right, let's move the letter. All right.
Inquire before I move to page 2, then, Your Honor.
Yes.
Doctor, this summary listing on this page, 6 items, starting with item number 1, what does that refer to?
As you recall, on Tuesday, last week, I showed you where the homicide cases are normally stored. That is in that crypt area where there were different levels where the gurneys could be placed. I also showed you on Tuesday a separate area in the coroner's office, the third autopsy room with closed, where there are locked doors available. Basically, this refers to that placing certain types of cases where there's a lot of interest to place them in a more secure area in a locked crypt. That's what he's trying to refer to here.
Was there any security for the bodies of these two decedents?
All bodies are in full security because they are in the coroner's office in the cold crypt area, and nobody can enter it unless you're a coroner's employee. And what is meant here is little more security, locking the bodies in a secure area. That's what that means. It doesn't mean that the bodies are not secure. Every body in the coroner's office is secure in the cold crypt area, which I already showed all of you on Tuesday last week. If you want, you can show the photographs again. We can explain this a little better.
I think we can recall that particular location. I'd rather try and get through this list of items if we could, Doctor. Item number 2, what does that refer to?
Preventing uninvolved employees from observing dissidents should have occurred. Again, this is a personal opinion expressed, I think.
You have to keep your voice
It's
up.
a personal opinion expressed. basically in a coroner's office we have visitors, I mean volunteers, we have sometimes people coming to watch autopsies, especially medical students and other pathology staff. And what is meant by this is
Man,
if you keep the residents secure,
man, did you have to watch an autopsy to become a nurse? It makes sense that you would have to, right? Maybe that would make sense to me. That you would have had to have done that.
only the person who's responsible for the particular case will be able to visualize to view the, not visualize, view the remains, because they are the only persons who need to be involved with the particular case. This is what is meant by this sentence.
Doctor, were any personnel not directly involved in the autopsies in that location of number 6, that table number 6, where you testified
Did any
the
of your
autopsies were
classmates
performed during the
pass
course of
out?
those 2 autopsies?
No.
My recollection is the detectives were there. As I told you, I
darn.
went there twice briefly. I was not there all the time. The detectives were there, and Dr. Golden was there. And of course, you see, we have 6 autopsy stations there, and autopsies are going on in every station. So you have pathologists there, our forensic technicians, and if some of them are homicides, you're going to have the detectives of those divisions there. If it's an in-custody death, you're going to have DA personnel there. Depends on the situation. I can't tell you who were there in the autopsy room, but all persons, to my knowledge, who should be there are the persons who are working on a particular case
Did
or have
anybody
to be there for
pass
some
out?
reason. And the other
The
personnel
students.
who could be in the corridors would be the cleaning personnel, if at all there were any there that day. I don't know.
How about item number 3? We've already talked about the fact that the stomach contents of Nicole Brown Simpson were not saved, and you testified as to the reason why you asked Dr. Golden to save the stomach contents of Mr. Goldman. Beyond what you've already testified to, is there anything else that concerns item number 3?
Nothing. It's a factual statement. We didn't save Nicole's stomach contents.
Is item number 4 something you've also testified about when we were looking at the Form 15 on the autopsy forms for Mr. Goldman?
Yes, that is just that he collected the bile. Everything is recorded properly, but only thing is on the bottle, the urine box was marked and not bile.
Item number 5, I believe we had testimony when we were doing the photographs of the coroner's office. We also looked at photographs of various kits, including the fingernail kits kit for Nicole Brown Simpson. Is there anything beyond what you've already testified to that concerns item number 5?
No.
What about item number 6?
Item number 6 is refers to when the clothing is dried, the correct procedure is to place each item of clothing in a separate brown paper, wrap them separately. On June 22nd, when Dr. Barden was there to see the evidence specimens, we found that Nicole Brown Simpson's panty and dress had been wrapped in the same envelope, and that's what this refers to.
And what, if any, significance from a forensic pathologist standpoint is there regarding having the panties and the dress wrapped together?
Well, it's the same person's clothing, and as you recall the scene photographs, the dress was overlying the panty when, if at all, if there was any blood staining there, it was already in contact. It's not a correct procedure, so that is a mistake. But as far as the significance in this particular case, I don't think it has much significance because the clothing was put together only after it was dry, and it's happened, and it's recorded.
Motion is great, non-responsive, last portion.
I'm sorry, the last portion.
Last portion of the answer was non-responsive.
Can I have a moment?
Yes. The jury is to disregard the last comment regarding the significance of this. Proceed. That was non-responsive to the question.
Doctor, have you evaluated, as part of your preparation before testifying, the significance
Only you
if
had
any, of
Lidocaine
putting those 2
patches.
pieces of clothing together?
Yes.
What is the significance, if any, for having done that?
Objection called for speculation.
Overruled.
Also goes beyond the expertise of this witness.
Overruled.
You may answer the question, Doctor.
All I said already, they were placed together and the clothing was already dry. What I'm trying to say is this: I don't see anything new would have occurred even if they had been placed together, that any new evidence would have been transferred from each other because they belong to the same person. That's what I meant.
Anything else about item 6?
No.
Could we have Mr. Fairwell then put the first portion of page 2 of this exhibit on 365? Oh, I think Mr. Fairwell would be benefited by having page 2.
7, what does that refer to?
Well, it's self-explanatory. Apparently, a reporter was in our lunchroom without our knowledge, and that's an indication for the security for the building, and that again states a fact which apparently happened.
Doctor, where is the lunchroom? First of all, is your building a building of more than one floor?
We have two buildings. Mine. It's not mine.
Thank you, Mr. Harris.
Doctor, you were describing the physical layout of the coroner's office.
We have two buildings in the coroner's office. We have the 1102 building and the 1104 building. The 1104 building is the medical building, the lab building, and the autopsy area. It's got 4 floors, a basement, a service floor, first floor, and a second floor.
Doctor, where is the lunchroom referred to in item 7 located in the 1104 medical facility?
We have lunchroom in 2 of the floors, in the first floor and the second floor, and this refers to the first floor lunchroom,
Doctor, on what floor are the autopsies performed?
the service floor.
In order to get to the service floor, how is one able to do that?
It's a security floor. You need a key to get to the service floor, or one of the coroner's employees has to personally take you down there. You cannot go to the service floor without a key.
And are keys handed out to persons other than employees of the coroner's office?
No.
Do all employees of the coroner's office have keys which allow access to the service floor?
Only those employees who need access to the service floor.
And they would include whom?
The doctors, the technicians, the lab personnel, the investigators.
Anything else about item 7?
No.
What about item 8?
Item 8 refers to trying to have a response team from the coroner's office on certain types of cases wherein you have a team of a pathologist, a criminalist, an investigator, and transport person go to a scene. Well, that is just a situation which we do sometimes when we have the necessity to do it.
Doctor, is this a wish list to
Yes.
some degree?
Yes.
Do you have the resources to do that in every case that's recommended in item 8?
Objection being suggested.
Sustain, rephrase the question.
Doctor, what resources would be required in order to do that recommendation in every case?
You would need more.
Irrelevant, we do it again.
Overruled.
You need more personnel in each division to.
I'm-
You would need more personnel in each area so that you have them available, because, in our office, many of the employees wear different hats. For example, our criminalist is also our toxicologist. Pathologist need for autopsy, but he also has to go to court. So if you have more staff, you can have the luxury of sending people to every scene, but it's not practical.
And you already, I believe, have testified last week regarding whether, in your opinion, it would have made any significant difference on the issue of the coroner visiting the Bundy location at the time the bodies were still there.
Yes.
Anything further about item 8?
No.
How about item 9?
Item 9 refers to the coroner's office not having been allowed access to dissident by LAPD for 10 hours.
We're going to discuss that, I believe, when we talk about time of death. Correct, Doctor?
Yes.
All right, let's go to item number 10.
This refers to, there was a request for valve procurement on Ms. Brown Simpson, and that is a routine procedure in our office, wherein, as you know, organs for transplant is obtained from different people if the family agrees to donate the organs, and usually the certain organs are removed from individuals where such permission is obtained, and our office is quite cooperative with all the organ procurement agencies as long as it doesn't interfere with our cause of death determination and injury interpretation. In this particular instance, this refers to heart valve donation being allowed by the Simpson family, and when it was brought to my attention, I denied it in the night, and in this particular case, and that's what this refers to.
Why did you deny it, Doctor?
Because heart valve donation is an intrusive process, because I would prefer that the DME is available to be there, the medical examiner who does the autopsy to be there when the valve is taken. And any organ procurement has to be done in a particular time frame. You can't just do it any time and use the valve. There was a time frame constraint here. The doctor assigned was Dr. Golden, because remember on June 13th I assigned the cases to him. This request was brought to my attention in the night, in the evening of June 13th. Apparently one of my assistant doctors had given permission, but he asked the organ procurement agency to contact me, and I, at that time, told them no, because Dr. Golden was not the one who was going to be there. They had got another doctor there who was, because as I told you, in our office, we like a doctor to watch the procedure so that he knows exactly, or she knows exactly what was being done because you open the chest, you take the valve, so you have to collect the blood sample properly. So there's a lot of procedures involved in this. So I made the medical decision, since Dr. Golden was not available in the night, to go through this procedure, and they had already got another doctor there, and I felt in the best interest of the department that this procedure not be carried out, and that was my decision.
Now, should I do one more or stop?
Well, let's take a break here. All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations until the matter has been submitted to you, or allow anybody to communicate with you with regard to the case. We'll stand in recess for 15 minutes. And Ms. Fitzpatrick, can I talk to you, please?
You think Miss Fitzpatrick had the beeper?
All right, back on the record in the Simpson matter, all counsel and the defendant are again present, meaning Mr. Shapiro and Mr. Kelberg for these purposes. Mr. Kelberg, you had something?
Very briefly, I've informed Mr. Shapiro that Mr. Hernandez from the coroner's office called. He found no such memorandum from the district attorney's office concerning Dr. Golden. He did a record
I
search,
can't
and Dr.
hear you,
Lachman
sir.
told me that you had talked to Mr. Hernandez as well, and that was the same information he had received.
Apparently Mr. Shapiro had some information to the contrary, that there was some of these items in existence.
The form, Mr. Shapiro was going to show me a form, which I am familiar with, in the EME manual, that is a suggested form to be used. They asked for any completed form, specifically with reference to Dr. Golden. The information is that I've indicated for the record. If Mr. Shapiro has something else, I'd be glad to go back and search it out further.
Yes, we do, Your Honor. We would ask the court to direct Mr. Kelberg's attention to the case of George Wilson McGowan, McGowan. The information that's been furnished to us is that there were direct orders issued by the judge in that case to the district attorney to notify the coroner directly about errors that had taken place, and that resulted in the capital murder case being abruptly ended and the judge making a finding of factual innocence.
If Mr. Shapiro has a coroner's case number, it would certainly...
Yes, I do.
Perhaps we can just pull that file, in its entirety.
Dr. Lachman has that number also.
Apparently he does.
Okay, I'll give it to him. He reported it to a reporter from the Los Angeles Times on...
Well, we need the coroner case number so we get the file.
We are inundated with a massive documents, so the court will bear with me for a moment. Response to Mr. Ralph Remolino's inquiry from the Los Angeles Times, and it's referring to case number 9009679.
And does the court wish Dr. Lachman to call Mr. Hernandez at this moment?
Yes. I'd like that to be available to the court, hopefully before the noon hour, so counsel can have the opportunity to review the file. Because I suspect it may be fodder for cross-examination.
Maybe not, Judge. Maybe there is no cross-examination.
Dr.
Maybe they're just going to set him free.
And have the entire case filed with that number brought to the court and hopefully before the...
Oh, I just thought of something bad. So, okay. So this guy's only on the stand for 3 more days, right? Okay. I feel like with as much direct exam that went on, days and days and days and days and days, cross should be more than just 3 days for this guy. So what I'm wondering is, and I don't know, I'm wondering if, like, we have 3 days of him in cross-examination, and then he's missing from
All
the
right,
next...
Mr. Kelberg, do you have all the other exhibits handy that you need to
Few?
proceed with?
Because we have, like, sidebars for a couple days, and then he comes back. I don't think so. Here's why. All right. I think we are here. I thought we moved down to here sometime, but maybe we didn't know because we've only been at it for an hour. We're here. We see him here. That's another day. Here, these two are another day. And this is the 3rd day. 3 more days. With him questioning, this could be a 4th day. I don't see him. That's why I don't know. These are new players. So definitely after 4th day, he's not there anymore. Right? Look, he doesn't come back right now. I don't know if he comes back later. No idea. But it's 4 days. It's 4 days tops of him because there's someone else on the stand. There's someone else on the stand for a little bit. And then this is this is somebody new. This is somebody new. And this is July. Looks like the defense is going well faster than the prosecutor's office. Oops. So no, he does not come back. 3 days, 4 days.
All right.
Can't think of anything I can do without the witness.
Hi, Zach.
Well, is there another member of your staff who can make this phone call on his behalf?
Dr. Blackmon and Mr. Lynch, the phone number.
All right. Please. Since prosecution has another hour and 8 minutes.
Well, Your Honor, I hope the court will understand the need to perhaps have a short period of the afternoon devoted to the completion of the time of death material, since that appears to have been a major issue. And I think the jury's got the benefit of as much information on it as scientifically is available for their consideration.
When we spend a lot of time on relative minutia.
It's fine. It's
Fortunately,
very
Your Honor,
early.
from my perspective, the
Very,
issue was
very,
raised
very
long
early.
ago, and it's only at this point
And I'm
that
talking over this guy because you can't hear him.
Well, I just want to express to you my concern about undue consumption of time.
I understand. I have one short area other than the one that we are discussing right now before I get into time of death.
All right, Deputy Magnolis, have the jurors, please. Yes, please.
Oh, that's a good question, Nan. I do not know.
All right, let the record reflect we've been rejoined by all the members of our jury panel, and Mr. Kelberg, you may conclude your direct examination.
Dr. Fairlow can bring back Exhibit 365. We're on page 2. I believe we are on item 11. And does that refer to what we were discussing yesterday? And we also discussed it with respect to the
Clerk
Nicole Brown
Vibes is
Simpson
absolutely not
autopsy
putting
of
anything
the
out
initial
later
request
today.
for a H screen and your decision to order a C screen, toxicological screen in each of those cases.
Yes.
Is there anything else to add to that?
No.
Item 12, did you discuss earlier in your testimony regarding fluoroscopy as a form of X-ray?
Yes.
And have you discussed what was or was not done in the form of X-ray?
Yes, I have.
And doctor, in your opinion, would fluoroscopy have been desirable in this case, as Mr. Sigler's letter indicates?
No, I think in stab wound cases, X-rays are better because if at all there are going to be any fragments of the knife, it's better seen on an X-ray than fluoroscopy. But sometimes fluoroscopy can help, but I would prefer to have an X-ray of an area because even if the fluoroscopy doesn't show it, sometimes you'll see it on the X-ray because fluoroscopy doesn't have the resolution, fine resolution of an X-ray.
Doctor, did you also testify, however, that no X-rays were taken, for example, of the skulls of either victim?
That's correct.
And we asked you questions about whether, in your opinion, there was
I
any
worked
indication
today.
that the blade of the knife had broken off
gonna work
in the
hard.
course of any of the infliction of the sharp force injuries. Do you recall that?
Yes, I do.
In your opinion, is there any evidence to indicate that that had occurred?
No.
Objection, Your Honor. Obviously, if they didn't do the test, they couldn't find evidence.
Overruled.
Your Honor.
That was a speaking objection, counsel.
Thank you, Your Honor. Doctor, anything further about item 12?
$250, sir.
Item 13. What does that refer to?
Oh, that refers to in the week following the autopsy, there was request for photographs from our office because there's a grand jury hearing on the case, and our machine was not functioning. You know, after the earthquake, we had some problems with our printer and processor, and now we have a new photographic equipment available. And basically, I requested LAPD to cooperate and make the prints for us. So we made a one print set for us and one print set for the grand jury hearings. And what Mr. Siegler is referring to is he feels that the prints could have been made by sheriff than LAPD. So it's just a matter of which agency you choose. And to me, it doesn't make any difference because LAPD was nearby. They were handling the case on these two dissidents, and I requested LAPD.
How about the next item? What does that refer to?
Oh, 14 photographic prints could have been available to the assigned pathologist prior to review of the medical protocol. This is a procedure which is being at least done on some of the cases, wherein the pathologist looks at the photographs before the protocol is signed to see for any problems we may have with reference to injuries not being described, or also to see whether the injuries which have been described are correct.
And is there some delay in the normal course of your business about getting the photograph with respect to your requirement to have the protocol dictated within 24 hours of the completion of the autopsy?
That is correct. But right now, we have the new equipment which just came following the earthquake. We got a new piece of equipment wherein you can have contact prints available 1 hour after the photography is done. So what I'm trying to do at the current time is to have some contact prints available to the doctors before they even do the autopsy to make sure that all the injuries are photographed. And this again is a laborious procedure, and we're trying to do it, but it's not been very successful, but that's the goal.
What is a contact print, just so we'll understand?
Contact prints, the print is the same size as the negative, so you have one strip with all the photographs taken on the case, so the doctor knows which areas have been photographed. This is something new we are trying to do in our office.
How about the next item, item 15?
Oh, that refers to to have bottles made depending on what kind of case you're dealing with, reference to toxicology samples. If you have a suspected suicide, you make all the specimens available, the containers available for a full tox collection, because you like to have liver samples, stomach contents, bile, urine, so that you can correlate the blood levels with the tissue levels and support your diagnosis or don't support your diagnosis of suicide.
Is there anything about this observation by Mr. Siegler that affects your ability to evaluate the evidence in these two autopsy cases?
No, I think the decision on what specimens to collect is the decision of the medical examiner. It's a medical decision. You have to use it intelligently to decide what you'd want done in a particular case. So this would apply because we do have residents coming into our office who work under supervision, and this is something which is already in place. We do a full talks on certain types of cases, and certain type of cases we just collect blood, like in traffic accidents I already mentioned, we collect blood and urine, depending on the nature of the case.
Next item, item 16.
That is just a statement. One of the diagrams was not available at the time of initial release of documents, and it was released to the defense team when I met them on June 22nd. It was one diagram form which was misplaced and later retrieved and presented to all parties concerned.
Dr., was this a type of diagram such as we've been using in the course of the discussion of these two autopsies?
Yes.
Anything else about item 16?
No.
Mr. Fairwell, can you show us the rest of that page, please?
What if Paris did show up, though? Wouldn't that be crazy?
If we just lower it to, I think, C. Doctor, can you identify, obviously we know who the middle name is, the first and third names for the copies?
Mr. Hernandez is the director of the department. He's in charge of all non-physician operations. Mr. Scott Carrier is the public information officer.
And Mr. Farrell will put on a single page that is the last part of this exhibit 365. Doctor, in general terms, what is this document?
This is the notes taken by Gary Siegler during the medical examiner's meeting on June 23rd, 94. And these notes were used by him to generate that letter which we just discussed.
So these handwritten entries then relate to what is later included in the listed 16 items in the letter to Mr. Hodgman?
That's correct.
I don't think we, I'll leave it up to the court if the court wishes the ladies and gentlemen of the jury to have an opportunity to read it.
Let's give them an opportunity to at least get a flavor for what it is. Mr. Kelberg.
If I could inquire just briefly while we're showing this portion. Doctor, item 7, incidentally, just initially, this appears to be a shorthanded version of the items. For example, looking at item 2, appears Mr. Sigler has handwritten looky-loos, and in the type document, item 2 is preventing uninvolved employees from observing decedents should have occurred. Is this, again, to be a shorthanded method of note-taking?
Yes.
Now, looking at item 7, the late call-out, liver temp / sexual assault.
I mean 9, item 9.
Oh, I'm sorry. You're correct. Item 9. And perhaps Mr. Farrell could raise that. We're going to talk about, as part of time of death, this issue of when your office was notified, when Ms. Ratcliffe went, and so forth. With respect to the sexual assault entry here, Doctor, what, if anything, different than what we discussed with you on the appropriateness or inappropriateness of taking a sexual assault kit, in this case of Nicole Brown Simpson, is referred to by that entry?
Nothing further to add.
Your Honor, do you wish to give the jury's...
No, I think we've seen this now.
All right. Thank you, Mr. Hurst. I have one other area of inquiry before talking to you, Doctor, about time of death. And we raised it earlier dealing with Claudine Ratcliffe, your investigator who went to the Bundy location. And it concerns the issue of taking blood samples of some form from a back of Nicole Brown Simpson. Do you recall that general area?
Yes.
And you testified, I believe already, even today, that when the body arrived at the coroner's office on the 13th of June, you asked Mr. Mahaney, one of your criminalists, to take blood samples from 2 areas of Nicole Brown Simpson's body as reflected on the appropriate evidence log. Is that correct?
He took blood samples from 2 areas.
And that's reflected in the appropriate evidence log, correct?
Yes.
Now I want to talk to you. Mr. Lynch, could you take one of the easels, just very briefly, and put it in the location where we use the photographs? And Doctor, again, with the court's permission, would you step down? This is Exhibit 354, Your Honor. Doctor, first of all, do you see the area where you asked Mr. Mahaney to take samples from when you saw the body at your offices on June 13th?
He made the determination which areas to take. I think he took the right thigh and calf area, these blood samples.
All right, referring to photograph CS11 and the area of the right leg where you're pointing and down further below the knee. Is that correct?
Yes.
I want to invite your attention both to the back of Nicole Brown Simpson as seen in CS11 and the back of Nicole Brown Simpson as seen in CS12. Do you see what appears to you to be blood on the back of her body?
Yes.
Would you have expected Claudine Ratcliffe to have taken any action at the scene to have that blood collected?
If she had seen it and she felt it was important, she would have asked it to be collected.
Doctor, would you have...
Motion to strike, non-responsive.
Overruled.
Doctor, would you have considered it significant in any way such that you would have expected her to have had action taken to obtain those samples?
If it had been seen, I think it should have been taken.
Why?
Because you don't have any injury in that area, and you have blood drops there, and this could be blood drops falling off a weapon, which could reflect the blood of the dissident, could be the blood of the, if in this case we have a second victim, it could have also reflected if the perpetrator had some injury, which can happen sometimes, and the perpetrator's blood. So it could be, it's good to collect and see whose blood it is.
Does the failure, and there was no effort made by Ms. Radcliffe to have that collected as far as you understand, is that correct?
It was not collected as for all the evidence logs we showed.
Doctor, is the failure to have that collected a matter which causes you to be unable to determine the issues you have been talking about for the last week or so?
Objection made.
Sustained.
Doctor, is the absence of that evidence such that you cannot form opinions as a forensic pathologist with respect to the cause of death?
It's nothing to do with the cause of death.
Is there anything about the absence of that evidence which prevents you as a forensic pathologist from determining whether a single-edged knife caused each and every one of the sharp force injuries you identified in the course of your review?
This evidence has no bearing on that conclusion.
You know,
Doctor,
Zach
is there
and
any
Josh,
significance without that evidence to
you missed some riveting testimony. It had us all glued to the screen.
your ability as a forensic pathologist to determine how long it would take to cause all of these injuries on these two people?
Again, this evidence will not have any bearing to those conclusions or opinions I rendered.
Doctor, is the absence of that evidence of any significance to you as a forensic pathologist in ascertaining whether one person armed with a single-edged knife of approximately 6-inch length, tapering at the tip, could have killed both of these human beings?
Again, this evidence collection would not have had any effect on my opinions on those those issues which you brought up.
In your opinion, could the evidence have, if taken, have been helpful to you, even if it does not prevent you from answering the questions I've asked?
If it had been collected, it will be one more piece of information which is available. If it's the blood of Ms. Simpson, then it will reflect that the blood drops are hers and falling off the weapon, and that would also support my opinion that
This
the
is equally as riveting
perpetrator
as
was
what you missed.
in the back, from the back, lifted the head while she was face down and cut her neck.
And if, for example, it was blood that was tested and found to genetically match blood drops found along the walkway leading to the back of the property, and which further matched genetically to that of Mr. Simpson, the defendant, would that have been helpful to you also in evaluating whether one perpetrator could have killed both of these two human beings in a brief, swift, and violent attack?
It would suggest, if that blood sample matched the perpetrator, and it would suggest that at least one perpetrator was involved with this evidence.
Is there anything further about that issue, Doctor?
No.
Brief follow-up to that, Doctor. In the investigator's manual, which you talked about on sexual assault kits, and inviting counsel to page 6.0.1, under field evidence procedures, is this what your investigators are instructed to do?
Excuse me just a second. Mr. Shapiro, do you have that available?
I can walk over and show it. It might be quick.
All right.
Bobby's back. How is your coffee today? Did you spike it with some hot sauce?
Again, Doctor, referring to page 6.0.1, is this part of what your investigators, such as Ms. Radcliffe, are instructed to do at scenes like the Bundy location? Under field evidence procedures, it is recognized that each death scene is unique and that the proper procedures for examining the decedent for evidence and the order of implementation of those procedures are dependent upon the circumstances of a particular case. Coroner's personnel conducting an investigation at the scene of a death shall communicate and cooperate with investigative personnel from the investigating police agency to determine the best manner in which to proceed. Is that part of what they are instructed to do?
Yes.
And one other manual.
So
Doctor,
she
is there
can
something
handle
called
it.
an Operations Bureau manual?
Yes, that is the manual which is used by the investigations division of our office, their procedures.
Put some pep in his step.
Just a moment.
Oh, you may not, sir. Sir, I said no. I can't believe they're not listening to me. Oh, it's the end of this video. Yes, sir.
Thank you, Your Honor. And the decedent is at the location of death or at the place discovered, a coroner's investigator will be assigned and dispatched to conduct the death investigation. Further on, field investigators are responsible for maintaining the integrity of a death scene, including information and evidence. They coordinate their investigations with investigators of other agencies also having jurisdiction of the scene. They functionally supervise other coroner employees at a scene, including any personnel charged with the responsibility of transporting the body. And dropping further down to a part under the word evidence, coroners investigators coordinate their investigations with police officers or members of other investigative agencies so as not to mishandle or contaminate evidence in which all may be interested. When the coroner's investigator determines the need to have a coroner's criminalist respond to the scene for the purpose of collecting trace evidence or evidence of sexual assault, they will protect the scene until the criminalist arrives. In these instances, the criminalist will collect all evidence associated with the decedent. Are those instructions that are given to your investigators, such as Ms. Ratcliffe?
Yes.
Now, Doctor, let me move into my final area of inquiry, dealing with the issue of time of death. And let me begin, if we could please, with a brief review of the legal requirements regarding notification of the coroner's office when a body has been found. Doctor, are you familiar with various statutes in the Government Code and the Health and Safety Code that pertain to this issue of notification of the coroner?
Yes, in a general way.
Let me invite your attention, if I could please, to several sections of Government Code, starting with a section of Section 27491 of the Government Code under the heading Duty to Investigate and Determine Cause of Death. In the fifth full paragraph, any funeral director, physician, or other person who has charge of a deceased person's body when death occurred as a result of any of the causes or circumstances described in this section shall immediately notify the coroner. Any person who does not notify the coroner as required by this section is guilty of a misdemeanor. Is that one of the sections of which you are familiar pertaining to the duty to notify your office?
Yes.
And obviously, this type of situation of two people killed in a manner suggesting a criminal homicide would be one of the areas covered by this statute. Is that correct?
Yes.
And when it says funeral director, physician, or other person, you understand that to include police officers. Is that correct?
Yes.
Now let me drop down to 27491.2 under. And as I was saying, dropping down to 27491.2. A. The coroner or the coroner's appointed deputy, on being informed of a death and finding it to fall into the classification of deaths requiring his or her inquiry, may immediately proceed to where the body lies, examine the body, make identification, make inquiry into the circumstances, manner, and means of death, and, as circumstances warrant, either order its removal for further investigation or disposition or release the body to the next of kin. Is that another section of which you are familiar regarding the responsibilities of the coroner's office?
Yes.
And, Doctor, would it be accurate to say that your office has the responsibility over the body itself,
Yes.
not the police agency?
That is correct.
Now let me invite your attention under one more section of the Government Code, 27491.3, under control of premises where body found, subsection C, the middle of that subsection as follows. At the scene of any death, when it is immediately apparent or when it has not been previously recognized, and the coroner's examination reveals that police investigation or criminal prosecution may ensue, the coroner shall not further disturb the body or any related evidence until the law enforcement agency has had reasonable opportunity to respond to the scene if their purposes so require and they so request. Custody and control of the body shall remain with the coroner at all times. Reasonable time at the scene shall be allowed by the coroner for criminal investigation by other law enforcement agencies, with the time and location of removal of the remains to a convenient place to be determined at the discretion of the coroner. Is that another one of the sections of which you are familiar?
Yes.
And doctor, how does this section affect the relationship between your people, including your investigators like Ms. Radcliffe, and police investigators such as Detectives Lang and Van Adder?
Basically, our office investigators cooperate with the police agencies if they require more time to collect evidence at a scene. That is one aspect of the government code which you just alluded to, that is 27491.3C indicates that. But the notification also is responsible to the police department to call us as soon as they have a death.
And that's what I want to next discuss with you. Doctor, given the resources your office has, do you automatically respond at the time you are notified that there is a body found by a police agency which believes the body is the product of a criminal event?
The way it works is when they notify us, the inquiry is when they give us a time when we can come and pick up the remains, because they may not have finished their criminal investigation and evidence collection, because we have limited resources of our personnel, because we like to go to the scene and do our investigation and bring the remains back to our office as soon as possible. And as we discussed earlier, if necessary, the criminalist will be called, and evidence collection by our criminalist from the body may take place at the scene also. So it is a situation where we need to plan our response to a crime scene. So we'd like to be notified when a death is recovered, when a death is discovered rather, and the response would depend on what kind of investigation is being conducted by the law enforcement agency, so that we can plan our response, so that our investigators don't spend time there waiting for evidence to be collected. And this is something where communication helps to have a kind of situation where both agencies conduct their responsibilities in a manner which is fit, so that the criminal investigation of a particular crime doesn't suffer.
Doctor, in the course of reviewing materials for this case, have you become aware of 2 telephone conversations between a police detective from the Los Angeles Police Department named Detective Phillips and 2 employees of the coroner's office, one Mr. Willis, W-I-L-L-I-S, and one Mr. Heath, H-E-A-T-H?
Yes, I had the opportunity to read the transcript. As you know, all calls coming to the coroner's office are recorded, and I had a chance to read the transcript of the recorded information which came to our facility with reference to those communications between Mr. Phillips and Mr. Willis, and later Mr. Phillips and one, I think, Mr. Heath of our office.
Doctor, assuming that there's been testimony in this court that the bodies were first observed by a Los Angeles Police Department officer by the name of Risky at about 12:13 a.m. on June 13th, 1994, and that the first call by the police to your office occurred at 6:49 a.m., or about 6.5 hours later on the same date. In your opinion, Doctor, was that timely notification to you as required by the sections that we've just reviewed?
No.
Doctor, in your review of these materials, have you attempted to form an opinion regarding the estimated time of death for Nicole Brown Simpson?
Yes, I have.
Have you also attempted, from your review of these materials, to form an estimated time of death for Ronald Goldman?
Yes.
And before I ask you if you have in fact formed such opinions and what they are, let me first ask you, in your opinion, Doctor, has the delay of 6.5 hours with respect to the first notification, and the fact, as we've already seen, that liver temperatures were not taken until approximately 10:40 and 10:50 a.m. on June 13th, as documented in our exhibits 298A and B, those Form 1s, has that set of circumstances, Doctor, caused you to be unable to form an opinion regarding the estimated time of death in each case?
No.
And further, Doctor, if by some fortuitous quirk of fate you had been with Officer Risky on June 13th at 12:13 a.m. on that date, with whatever bag of medical paraphernalia you would use for ascertaining the medical information from which you form an opinion as to cause of death, in your opinion, would you, under those circumstances, have been able to determine whether the death occurred at 10:15 p.m. on June 12th rather than 11 o'clock on June 12th?
No.
Would you be able to exclude any time period between 10:15 and 11 o'clock on June 12th if hypothetically you had been fortuitously with Detective or Officer Risky at 12:13 and had done whatever you are able to do medically to make such determinations?
No.
Now, Doctor, and we're going to go through why you hold that opinion. Is that correct?
That is correct.
Let's start with, what is your opinion with respect to the estimated time of death for Nicole Brown Simpson?
I cannot tell exactly at what time she died, but she obviously I have taken all the factors into consideration. I can't pinpoint exactly what time she died between 9:40 and 12:40 when the body was discovered, but based on the parameters which were evaluated, as liver temperature, rigor, liver, etc. But the only thing which would favor, and there's one more factor which one can take into consideration, which would include gastric emptying and contents, which show that there were identifiable food fragments in her stomach at the time of autopsy, identified as rigatoni and black olives, etc., which would reflect that. And also, I was told information that she ate the dinner somewhere between 8 and 8:15 that evening. Just using that, it would favor death took place between 10 and 30, but that again will not be a definite answer because that factor of gastric emptying and gastric digestion has so many variabilities to the process. So bottom line is I can't narrow a time of death between 9:40 and 12:30, which is the discovery time of the bodies, with precision more than what I've discussed.
And Doctor, is the factor, let me withdraw the question if I might. Doctor, I want you to focus solely on medical factors and not on any information you may have received in the form of, for example, a documented telephone conversation between Nicole Brown Simpson and her mother at about 9:35 in the evening of June 14th, and a documented call by Nicole Brown Simpson after that call to her mother, or that call from her mother to the Mezzaluna restaurant. I want you to set that aside and focus solely on medical bases for forming an opinion on cause, on time of death. Have you an opinion?
Overruled.
Have you an opinion, Doctor?
Sorry. The jury is to disregard the last deletion of factual circumstances, some of which are not in evidence yet. Let's just focus on the medical issues.
Have you formed an opinion as to a range during which the death of Nicole Brown Simpson occurred?
That could occur anywhere between 9 and, just on medical facts, if you give a range, it's anywhere between 9 and 12:45.
And we'll go through those medical facts. Do you have an opinion from the medical facts alone as to an estimated range for the time of death of Ronald Goldman?
It would be the same.
And Doctor, when forensic pathologists evaluate cases for time of death, do they attempt to provide a specific time or do they attempt something else?
They always give an estimated range because the parameters you use to estimate time of death are rough parameters, and you cannot be precise in giving a precise time of death. You always give an estimated range with a plus or minus of 3 hours for a particular time, which you estimate the death should have taken place, because you always have to give the range because the factors you use have so many variabilities inbuilt in them itself. So if you take those variabilities of the factors you use and apply them to a particular situation, you can only give an estimated range. You cannot give any precision to a particular time like 10:15 or 10:20. It's very difficult.
Doctor, in preparing for this area of your testimony, have you reviewed medical literature on the subject of estimation of a range for time of death?
Yes.
Is one of the materials you reviewed a book called The Estimation of the Time Since Death in the Early Postmortem Period by Henssge, H-E-N-S-S-G-E, Knight, K-N-I-G-H-T, Krompecher, K-R-O-M-P-E-C-H-E-R, Medea, M-A-D-E-A, and Noakes, N-O-K-E-S?
I referred to that book, yes.
And in fact, have you read this book?
I read the book to the areas which apply to the pathologist.
Doctor, when did this book come out?
This year, 1995.
Doctor, to your knowledge, is this the first book devoted entirely to this subject, the estimation of the time since death in the early postmortem period, that is published in English?
Yes.
Doctor, are you familiar with who these people are, Henssge, Knight, and so forth?
Yes.
Perhaps if Mr. Fairtlow could just put the face of the book up on the Elmo, and then the doctor can tell us who these people are.
Dr. Hensager works for the Institute of Forensic Medicine at the University of Essen in Germany. Essen, E-S-S-E-N. Mr.
What kind of institute is that, if you're aware?
It's a forensic institute. I've not been there, so it's a recognized forensic institution.
And the next name, Dr. Knight?
Dr. Knight is the professor of forensic pathology at University of Wales School of Medicine in Cardiff in the United Kingdom.
Before you go beyond his name, Doctor, is one of the materials you also reviewed a chapter regarding estimation of time of death found in a forensic pathology text with the name Bernard Knight Forensic Pathology.
Yes.
And is this a 1991 text?
Yes.
What is this kind of text?
It's a textbook of forensic pathology addressing different issues in forensic pathology used by pathologists and other forensic scientists to have information pertaining to that particular medical specialty.
Doctor, first of all, is Dr. Hensager recognized as one of the leading researchers in the area of estimation of time of death?
Yes, he has done a lot of work in this area, and his nomograms, which we'll be discussing later, has been developed taking some variable factors involved in the cooling of the body, and that nomogram, which we'll be discussing later, will give you a tool to apply certain findings you have when you examine a body, and when you apply it on the nomogram, you can come up with an estimated range. And again, it's an estimated range. It's not a time of death with precision.
Doctor, is Dr. Knight a preeminently recognized forensic pathologist?
Yes, he's well known in the forensic community. He has written this textbook. He also edits the other book, Keith Simpson.
And I was going to ask you about that. Is there another forensic pathology text that you reviewed the chapter on estimation of time of death entitled Simpson's, obviously no reference to the defendant, Simpson's Forensic Medicine, 10th edition, Bernard Knight?
Yes.
And the edition date of this, Doctor, is 1991?
Yes.
And are both of these books, with Dr. Knight as the editor, considered as recognized medical texts in the area of forensic pathology?
Yes.
All right. How about if we, do you know any of the other names?
Medea is known. He always writes papers with Dr. Hensager. Dr. Medea is from the University of Cologne, K-O-L-N, in Germany.
And is Dr. Medea one of the recognized researchers in the area of estimation of time of death?
Yes, most of the papers by Dr. Hensager has his name also.
Are you familiar with the other two names, Doctor?
Just when I read the book, Mr. Noakes works for the University of Wales, Cardiff. He's, I think, he's in the engineering department.
And actually, if we could ask Mr. Fairtlow to put the title page up. It has references to each of these people. I think we'll find it's Dr. Noakes. MD, doctor, stands for what?
Medical doctor.
Are you familiar with what MRCP stands for?
Yes, it stands for the member of the Royal College.
If you can't read that tiny little box on the screen, Josh said, are they trying to set another record for how long they can keep someone on a witness stand? It's just weird that we went through this. We just looked, Josh, and cross-examination 3 days tops, because then the fourth day would be redirect. That's it. Isn't that weird? Because he's been on the stand for, I think, 17 months now, 18 months. We could have had 3 babies by the time this guy has been on the stand. Oh, press play or he's never going to get off.
College of Physicians, and usually that's a diploma given in England. And
How about the other designations for Dr. Knight? Are you familiar with what they mean?
FRC Path is Fellow of the Royal College of Pathologists. DMJ is Diploma in Medical Jurisprudence, Pathology. Barrister, he's also a lawyer.
And dropping down to, it is Dr. Noakes, is it not?
Yes, I'm sorry, but he does work for the engineering department.
At the University of Wales in Cardiff?
Yes.
Now, Doctor, in reviewing this material, have you considered its contents in forming opinions?
Yes, But as I told, I only reviewed portions which apply to pathologists. There's a lot of material there which is mostly for mathematicians, statisticians, which I didn't pay attention to.
And in fact, is that part of the preface by Dr. Knight for people who are not inclined towards higher levels of mathematics, for those non-medical readers, including lawyers and police detective officers, as well as the many doctors who are unfamiliar with more advanced mathematics and physics? Some parts of the text can be avoided in favor of the more practical sections, which summarize the best current methods and indicate the limits of accuracy.
Yes.
And have you done that, Doctor?
Yes.
Doctor, have you relied, at least in part, on the information you have read in this book?
Yes, I have.
And as part of the material that you have relied upon in part, has the following been included from the preface. Though very many papers have been published on the subject, to the best of our knowledge, this is the first book in the English language to be devoted to the estimation of the time since death. As the historical review will indicate, the problem of determining the post-mortem interval, and is that a fancy way of saying how long a person has been dead?
That's correct.
Has exercised doctors and scientists for at least a century and a half, yet accuracy still remains beyond our grasp. This book does not pretend to solve this ancient difficulty, but offers a series of monographs by different authors which address various aspects of the problem. Particularly in relation to temperature-based methods, the opinions of different authors will be seen to vary, but this lack of consensus is familiar to all those working in forensic medicine. Part of what you referred to, considered, and relied upon, Doctor?
Yes.
And further, Doctor, did you refer to, consider, and rely in part on the following from the general introduction by Dr. Knight? The importance of estimating the time since death must have been appreciated for centuries, probably millennia. Even in the most unsophisticated societies, when homicides took place, the community would inevitably have correlated the location and movements of the prime suspects with the apparent time of death, however crude that comparison might have been, to test what would later become the defense of alibi. Little has changed from those early days, except that their data acquisition equipment was merely the back of a hand to test the coolness of the corpse's skin and their eyes and nose to evaluate decomposition. We now have multi-channel thermometry with thermocouples sensitive to a fraction of a degree, enzyme methods, vitreous chemistry, muscular reactivity, and several other avenues for collecting data. Regrettably, the accuracy of estimating the post-mortem interval has by no means kept pace with the enormous strides made in technical sophistication.
Overruled.
Doctor, again, part of what you have read, considered, and relied upon?
Yes.
And further, Doctor, it is not only the defense of alibi that has such relevance to the estimation of the post-mortem interval in criminal deaths. In the earliest stage of many criminal investigations, before any suspect is questioned or charged, a knowledge of the approximate time of death is vital if the investigating officers are to direct their inquiries in the appropriate direction. The relationship of the time of death to other events, to persons in the vicinity, and to those who could not have been in the vicinity will automatically channel investigative efforts along certain lines. When several suspects are being considered, the best estimate of the time of death forms a primary screening procedure to eliminate some putative killers who could not have had access to the deceased at the material time, and may strengthen suspicion against others whose movements coincided with the estimated time. There is thus a heavy responsibility upon the doctor who offers an opinion as to the probable time of death. If he or she is significantly in error, the investigation may be dislocated at its earliest and perhaps most vulnerable stage. The onus is therefore upon the doctor to provide a range, and the word range is italicized, of times within which he or she thinks the death occurred, which is as accurate as is justified in the circumstances. Even more importantly, it must not be so unreasonably precise as to exclude incorrectly the true time of death, as this may provide a false alibi for one or more suspects. To offer an unreasonably accurate time of death is worse than providing such...
How did nobody just get up and smack this lawyer? How is the judge letting him just stand there and read a freaking book? How? Just stop talking. You've said enough. That's not a question. Is that a question? Isn't he supposed to be asking questions? I'm asking questions. Okay, back to work.
Such a wide range of times that the police derive no help from it. In the latter situation, they at least then know that they have to use other methods in their investigation. But to mislead them by some outrageously precise time runs the risk of their excluding the true culprit, as well as falsely implicating an innocent party. Unfortunately, it is often the least experienced medical witness who tends to offer the most accurate estimate, not having seen enough cases to appreciate the many pitfalls and fallacies in the process. Certainly, with all the methods available up to the present time, the opinion of any doctor who offers a single, and the word single is italicized, time of death instead of a range, or one who includes any fraction of an hour instead of a whole hour, must be viewed with considerable skepticism. Doctor, have you read, considered, and relied in part on that information in forming your opinions?
Yes. Yes.
Doctor, have you also reviewed chapters from a book that you have previously
Don't you dare.
identified, Spitz and Fisher's
Don't you
Medical
dare.
Legal Investigation of Death, 3rd edition, edited by Dr. Spitz and dated 1993?
Yes, I have.
Have you also reviewed the materials related to estimation of time of death from another text called The Pathology of Homicide by Lester Adelson, Adelson, dated 1974?
Yes, I have.
By the way, are both of these books considered recognized forensic pathology textbooks?
Yes, they are.
Also,
So-
doctor, have you reviewed
Okay, I know 1974 sounds like it's way out of date. But 1974 to this day in court is a shorter time period than this day in court to where we are right now today.
two other books with respect to their chapters dealing with the estimation of the time of death?
Yes, I have.
One of which is called Gradwall's, Gradwohl, apostrophe S, Legal Medicine, 3rd edition, dated, I believe it's 1976.
Yes, I have.
And something called Modern Legal Medicine, Psychiatry, and Forensic Science by Curran, C-U-R-R-A-N, and others, dated 1980.
Yes, I have.
And also, doctor, have you reviewed specific individual medical articles concerning the estimation of the range for time of death?
Yes, I have.
All right, that's enough for one day. It's enough. We're going to start tomorrow with him reading 17 different chapters out of every single one of these freaking books to us. But it's okay. We're learning something. We're not learning anything because we're not listening. He's just trying to frustrate me. We're almost through this guy. It's a shame. It's a shame because the medical examiner should have been like, oh my God, testimony. Like, oh my God. Like, we should have been able to feel each wound, and we should be able to know exactly where, exactly where and how they were laying and how much it would have hurt, but it was that we didn't get there. I looked up something else. Josh sent me this timeline. I think I looked at that, but I'm not sure, but I'm going to pretend I did. To remember, I stopped it like a couple days ago. I stopped the stream and I said, this is how she was killed. He stood on her back. He lifted her head. But the medical examiner didn't get us there. Did not. What I'm waiting for, what should be next after the medical examiner, I hope, is the stuff about OJ. About, his prior domestic and his actions that day and stuff about OJ. That's what I'm thinking might be coming after they bored everybody to tears. They have to wrap it up with something emotional, right? That's what a lawyer would do, right? So we're going to pick this up tomorrow. Thank you so much for coming out, guys. I shall see you all again really, really, really soon. Hope you all have a badass Saturday. Bye, guys.